In Illinois, if an engagement is called off, several legal and personal considerations typically come into play. Number one, property and gifts. Illinois generally views engagement rings as a conditional gift given on the condition of marriage. If the engagement is broken off, the ring should be returned to the person who gave it. Other gifts of property acquired during the engagement may need to be divided or returned depending on the circumstances and the nature of the gifts. Number two, no fault for broken engagement. Illinois law does not assign fault in cases of broken engagement. This means neither party can sue the other for simply ending the engagement. Number three, legal agreements. If the couple entered into any legal agreements, like a prenuptial agreement, in anticipation of marriage, those agreements are generally considered void if the marriage does not take place. Number four, joint financial commitments. If the couple made any joint financial commitments, like a shared lease, mortgage, or large purchases, these need to be addressed and potentially renegotiated or dissolved. Number five, emotional considerations. Aside from legal implications, a broken engagement can have significant emotional and social consequences for both parties, and it may be beneficial to seek support from friends, family, or a professional counselor. Number six, wedding arrangements. If wedding plans were already underway, deposits and arrangements with vendors like venues, caterers, photographers need to be reviewed. Some deposits may be non-refundable, but early cancellation might minimize losses. Number seven, children and custody. If the couple has children together, the issue of custody and support needs to be addressed, although this will be separate from the engagement itself and handled as a matter of family law. It's important to handle these matters sensitively and, where necessary, seek legal advice to ensure that all legal and financial matters are resolved fairly and properly.